on that score, can we just step back a minute? I can certainly understand why these items should be made illegal. But we're dealing with a statute that was enacted in the 1930s. And through many administrations, the government took the position that these bump stocks are not machine guns. And then you adopted an interpretive rule, not even a legislative rule, saying otherwise, that would render between 250,000 and 500,000 people federal felons, and not even through an APA process they could challenge, subject to 10 years in federal prison. And the only way they can challenge it is if they're prosecuted. And they may well wind up dispossessed of guns, all guns in the future, as well as a lot of other civil rights, including the right to vote. And I guess I just want your reaction to that. And I believe there were a number of members of Congress, including Senator Feinstein, who said that this administrative action forestalled legislation that would have dealt with this topic directly, rather than trying to use a nearly 100-year-old statute in a way that many administrations hadn't anticipated. Thoughts?
There's a lot packed in there, so as you might expect, I have a lot of thoughts. I think the main one is this court often concludes that the government has interpreted a statute the wrong way and doesn't hesitate to correct the government's mistakes. I think the government should do the same thing. After the Las Vegas shooting, the deadliest shooting in our nation's history, I think it would have been irresponsible for the ATF not to take another closer look at this prior interpretation, which was reflected in a handful of classification letters, and to look at the problem more carefully. And having done that, I think it would have been irresponsible if the ATF concluded, as it did, that these devices are prohibited under the best reading of the statute, for the ATF not to fix its errors.
Then why not do a legislative rule properly, and in which, I know you did notice and comment, but it was an interpretive rule, and an interpretive rule you can more or less just issue. And you don't even have to put it in the Federal Register. I mean, maybe you do in some circumstances, but not all.
Well, Justice,
and you're creating a class of, again, between 250,000 and 500,000 people who have, in reliance on past administrations, Republican and Democrat, who said that this does not qualify under a very old statute, taken actions. And an interpretive rule, you can't even challenge in an APA posture.
well, we are in an APA posture. They are challenging an interpretive
rule. Well, I understand that, but in your reply brief, you say, don't touch that, because that's not before us. That's not part of the QP. And in an interpretive rule, you don't get an APA challenge. You get a criminal prosecution against you is what you get.
So I guess I disagree with that on a number of levels. First, I would think it would be better for those who are concerned about administrative power that we acknowledge this is an interpretive rule. The ATF doesn't have the power to make something a crime that wasn't a crime before. It's not a crime to violate the rule. It has been and always will be a crime to violate the statute. The ATF is saying we got that wrong before and we're fixing it now. And you're right. It would be horribly unfair to prosecute people who possess these devices in reliance on the agency's past assurance. But that is taken care of through doctrines like entrapment by estoppel, which ensure that no one has been and no one will be prosecuted for possessing these guns or these devices during a time when ATF said it was legal. But that's not a reason to shackle the ATF, and certainly not a reason to shackle this court to adopt something other than the best reading of the words Congress wrote. And it's true, Congress wrote those words 90 years ago, but we think it used capacious language, like function of a trigger instead of pull of a trigger. And then in 1968 added parts that can be used to convert something into a machine gun, precisely because it understood that Americans have a lot of ingenuity and a lot of creativity. There are a lot of ways to build something that is a machine gun, and I don't think you should hesitate from applying the broad language that Congress wrote, consistent with the meaning that it has always had.